Hi, my name is Damika Bates, and I am going to be presenting on search and seizure in schools. The Fourth Amendment of the Constitution guarantees the right for everyone to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Um, They shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Um, the question that many of us face in schools today is this concept of search and seizure. And, do we even have the right to privacy for students, even at school? And oftentimes, um, there are many constitutional rights that believe that the right applies to everyone, regardless of their age, race, gender. And there are many cases that have been pivotal in this idea of who has do students actually have the rights to privacy, and the Fourth Amendment is what we use when considering such things. So there are a couple slides that I want to talk about. What are school districts' rights to search and seizures? So, what rights do districts have when it comes to searching students in their properties? And so there was a historic case, and I'll talk about that a little bit later, with New Jersey versus TLO, which the Supreme Court held that the Fourth Amendment does apply to school, and that in order for search to be constitutionally valid, reasonableness must prevail. So, students do have a right to privacy that's protected by the Fourth Amendment, and it's predicated on two factors. One, whether the person in question showed an actual expectation of privacy, and two, the expectation of privacy be one that society deems reasonable. And so, there are two things that are considered when we look at search and seizure. Um, and both of those things, when we look at the evidence of the search, there are some legal things that have to be considered that you have to use as criteria for search. And those two things we use are probable cause versus reasonable suspicion. So, what is that? So, probable cause is kind of the highest standard that's required of a search. And what it does, it requires police to have sufficient evidence that you committed a crime, or that there is a possible chance that there's evidence that um, they can use to search your items or your belongings, right? But it requires more than mere suspicion or even reasonable suspicion. It's required of police before they can search you, and it's more stringent than reasonable suspicion. So, reasonable suspicion is the usual standard that's kind of used in schools and with school officials, and it doesn't really require um, a search warrant. It's less rigorous than probable cause, and most times school officials only need reasonable suspicion to search. According to Anderson and Anderson, reasonable suspicion is a belief or opinion based on the facts or circumstances. So there are three things that we look at when considering reasonable suspicion. School officials, they only need that. Probable cause is more stringent, is required for police, and a student's freedom from unreasonable search and seizure must be balanced against the need for officials to maintain order and discipline and to protect the health and welfare of all students. Um, there's also a concept under reasonable suspicion that we consider, and it's called inception of search. And the facts that lead to the initiation of a search must be legitimate from the inception. So, when that moment that you believe that there is going to be a search required, there have to be specific facts. And there are some factors that you have to consider when you're going to do this in school. And those factors are age, school record, reason for search, time, prior experience of the student, and reliability of the information that you obtained from whoever is reporting it. Um, the inception rule relies on a twofold inquiry. One, was the search justifiable at its inception? And two, the search was reasonable, related in scope to the circumstances which justified the interference in the first place. And there's a lot of talk about, what are the rights of police officers and police liaisons in the schools. And so when so what rights do they have? And when police are conducting searches without school officials, then the full Fourth Amendment rights apply. And there are a couple cases where we'll look at that too moving forward. So how do we determine the level of police? Well, is the police officer employed by the district, or is it acting with, you know, on the side of law enforcement agency? Um, Also, when determining an officer's purpose, they almost always find that if it involves school discipline or safety, even where there is evidence seeking bent to the search, um, then police can be found reasonable in searching those particular things. So there are a couple things also under the district's rights for search and seizures. There's a concept called suspicionless searches and special needs. And so, according to Alexander and Alexander, officials therefore may be held liable for damages for violation of a student's civil rights for illegal searches. However, as a general rule, qualified immunity shields school officials who perform their discretionary duties in a reasonable manner. So, what it's saying is if there is reasonable doubt, and they can be held liable if they're doing it without incident or without specific facts. But there are specific cases that we'll look at too, and types of searches that can happen in the school setting. So there can be a search of lockers. Um, there can be a search, strip searches are allowed as well. And in the search of lockers, the state versus AGC, there was a student that reported to a counselor that another student threatened to bring a gun. The counselor told the principal. The principal searched the book bag and did find a gun. But so the student claimed that the rights were violated, and this court ruled in favor of the school district. Strip searches in Safford versus Reading. A student was accused of giving out prescription strength ibuprofen. They searched the student, and when performing the search, the student was required to expose some private body parts. And when they filed the case, the court ruled in favor of the plaintiff because it was highly invasive and it was just for prescription strength ibuprofen. There's also canine searches, where in this particular case, there was a report of drugs. Police officials brought in dogs, and they had all the students removed from the classroom and had the dogs search the bags. So when parents filed a case, the courts ruled in favor of the school district because they said the dogs didn't actually search the persons, they searched the items. And that is what they determined was minimally intrusive. The New Jersey versus TLO, which I talked about in the beginning of the presentation, is pretty much the standard case in search and seizure. And this particular case is um, one of the Supreme Court cases that set the standard for conducting searches in schools. So a student was caught smoking in the bathroom. When she was searched, they found the student to be in possession of marijuana. The student took the case to the Supreme Court, stating that her Fourth Amendment rights had been violated due to her being searched without a warrant. But the court ruled that a warrant wasn't necessary because there was probable cause. And there are a couple other cases as well that talk about search and seizure in schools. So FP versus the state, where the school official exception to probable cause requirement did not apply when the search carried out at the direction of the police. So remember, if the police are inquiring and conducting the search and they're conducting it on behalf of law enforcement agency, then Fourth Amendment rights apply, and it will not hold up in court. Also, Katz versus United States was a very pivotal case in the Supreme Court. Cheney versus Fayette County Public Schools, where it was deemed that there was a professor that showed a student's picture that he found on Facebook in a bikini, and she said that her privacy rights were violated. However, because her settings were public, the court ruled in favor of the school district. There are some principles of search and seizure in schools that should be considered. So, when you're thinking about search, search is when you find things that are illegal or unsafe on school grounds. So, anything on school grounds like lockers, desks, classrooms can be things that are searched. And seizure is the concept of taking or confiscating items that are illegal or unsafe in schools. But where they are both similar and share many of the same things is they are both apply under the Fourth Amendment protections. There are reasonable expectations of privacy, probable cause versus reasonable suspicion. They must claims must be specific, require a warrant, and both school officials and law enforcement officers, if deemed reasonable, can conduct search and seizures. And it always is usually to maintain safety and discipline. I've also attached a reading list that can be perused for more information about search and seizure in schools. Um, Thank you. Have a great night.